Good morning, committee. Good morning, everyone that's joining us today in the audience and those that have joined us via Zoom. Welcome to House Labor, Health, and Social Services Committee. I hope everybody is well this morning. Mr. Caldwell, if you would call the roll, we'll call the meeting to order.
Representative Clauston.
Here.
Representative Guggenmoss.
Here.
Representative Heft.
Here.
Representative McCann.
Here.
Representative Ottman.
Here.
Representative Stivar. Representative Wasserberger.
Here.
Representative Yen.
Here.
Chairman Rodriguez Williams. We have a quorum.
Okay. I will briefly run through our committee rules. If you'd like to read along with me, you're welcome to get a copy of the rules out front of the committee meeting room. First of all, committee members and those in the audience, please keep your cell phones on silent. Although it may seem an awkward formality, speakers will address the comments and questions to the chairman, not to individual committee members or to others in attendance. This helps us avoid personalities and comments of a personal nature. Comments will be directed to the issue under discussion by the committee. Distracting comments on unrelated side issues will be called out of order. Speakers will avoid personal criticism, ridicule, or name-calling directed at anyone else in attendance at the meeting. This includes comments of a personal nature directed at other speakers, audience members, or members of the committee. For audience members, we expect you will refrain from any behavior that disrupts the orderly conduct of the meeting. Specifically, the rules prohibit speaking out loud when another person is talking, carrying on loud and distracting side conversations, no shouting, clapping, or booing in response to a speaker's comments. Our general guideline is very simple. We just ask that everyone conducts themselves in a civil and respectful manner at all times during the meeting. So we have 3 bills on the agenda here this morning, and we will be gaveling in on the House floor at 9 o'clock. The speakers asked us to gavel in early this morning. If we need to carry over until the evening to finish these 3 bills, committee members, we will be doing so. The first bill we'll hear is House Bill 339. The second on the agenda is House Bill 250, and the third is House Bill 289. That's the order these will be heard. So House Bill 339 is now on the table for consideration. The title of this bill is Homeowners Association's Display of Political Campaign Signs. The sponsor is Representative Weber. Good morning, Representative Weber. Welcome to our committee.
Thank you. Thank you, Madam Chairman and committee members. It is my privilege to present to you House Bill 339, a bill to prevent homeowners associations and condominium associations from prohibiting their members from placing election signs on their own private property during election season. This is a straightforward bill, completely bipartisan in nature, that would prevent these associations, corporate and non-corporate, from infringing on the rights of Wyoming citizens to exercise their rights to political free speech during a short period of time during every election season every 2 years. A little bit of background as to why we need this bill, which is already in place in many states and being considered by more. Many of you may not be aware that there is a federal statute, part of our flag code, called the Freedom of Display, the American Flag Act of 2005. I know I wasn't. It restricts homeowner and condominium associations from prohibiting one from flying our flag on one's own private property. In a state as patriotic as ours, such a statute would seem far from necessary. But in the hyper-patriotism following the attacks of 9/11 of 2001, when flag sales outpaced the ability to fill orders and people proudly flew our flag everywhere, in numbers seldom seen in modern times. Homeowner associations across the country, for less than patriotic reasons, stopped and fined, in many cases actually sued homeowners for displaying the flag, our American flag. Expensive lawsuits and hostility ensued. HOA contracts prohibiting signs were held binding by a few less than patriotic judges. Homeowners were subject to thousands, sometimes tens of thousands of dollars in fines and legal fees. And the situation worsened to the point where Representative Bartlett from Maryland was spurred to pass a law, a federal statute to make it illegal to ban flying of our flag by these associations. Also keep in mind that many HOA contracts require the homeowners to pay legal expenses of the association in any lawsuit against that association. This Bill 339 is meant to stop such prohibitions and actions from occurring in Wyoming. Every 2 years during the election season or during special elections, this bill, with strict restrictions on time, place, duration, and number of signs prohibiting obscenity and unsafe placement, will allow homeowners to exercise their right to political free speech and allow and their right as citizens to publicly support their candidates of any party or political affiliation without fear of retribution by their homeowners association. There is a legal reasoning behind bringing this bill. Well apart from saving the patriotic Wyomingites the burden of fines and legal expenses to express their political free speech, one may ask a homeowner, well, you had every opportunity to live elsewhere, and you signed a contract prohibiting signs, and now you must live with the consequences. The answer would be a slam dunk in a clause to any contract required that you be of a certain race, religion, political party, or sex. These things are illegal, but it is well established in contract law that no clause in a contract is enforceable if that clause is, 1, illegal, 2, not in the public interest. I don't believe that anyone in this room or in this building can tell me, apart from the private interest of a homeowner's corporation or condominium association, how preventing any citizen from exercising his political rights of political free speech is in the public interest. Of course, for a short period of time, and rarely things may become a little colorful, bright, exuberant, and spirited in the real estate development. But these issues are messy, and become spirited as we as Americans relish the trappings of our institutions. It is we who are as patriotic as Americans, and who we will always be. Limiting our expressions of support for our candidates, especially with the strict limitations stated within this bill, is just plain wrong. We need a law to prevent this. Some may say the law is unnecessary, and it is not a problem in Wyoming. Well, it is a problem in my area, in my county, and with the people from across the country moving here in large numbers, the growth of HOAs, mutual benefit associations, and condominiums is sure to increase. No patriotic Wyomingite should be required to expend thousands of dollars in legal expenses in court to establish case law to prove his right to political free speech on his own private property. This law will not require a penny of state money to defend. It will not lower real estate values. It will not set a precedent in corporate law outside of these homeowner associations. And it is common sense. Complete bipartisan and deliberate, considered, and purposeful act that other states have enacted or are considering across the United States. People move here because of what we have here. Freedom. Political free speech is one of those things. Let's not allow any segment of the population, no matter the size, to be singled out and unable to express this right. I ask that you vote in favor of this bill, a bill which is necessary now and will become more needed in the future.
Thank you, Representative Weber.
Thank you.
Committee, any questions regarding this bill for Representative Weber, the bill sponsor? Representative McCann.
Thank you, Madam Chair. On page 4 at the bottom, as far as the misdemeanor offenses, who does that go against? Is the HOA? Does that go against the HOA, or is there a person involved in that? I just want to know how that's going to be administered, I suppose.
Thank you, Representative McCann. Representative Weber.
Thank you, Madam Chairman, Representative McCann. I do have a few amendments, and I'm not sure is this where I would bring some of those up. And I think, Madam Chairman, is this where I would bring up the amendments that I would propose?
Sure, if it
or just-
pertains to the question
It
that
does.
the
This one does.
representatives asked, sure.
Thank you, Chairman. So on the misdemeanor offenses, when I was looking at this bill, I think we need, the amendment that I would offer is a lot less than 6 months in county jail or a fine of not more than $1,000 or both. I would like to have that and have LSO review what the statutes are, because I would like it to be the minimum amount possible.
Further questions, Representative Yin.
Madam Chairman, thank you. Representative Weber, I like the idea. But to follow up on Representative McCann's issue, it's not really sure how this would be targeted. My suggestion, and I'm curious in what your thoughts are, is to not include it in the misdemeanor offenses and essentially let someone go to court, take their HOA to court if the HOA violated it. So it would still just be a civil action.
Representative Gugemas. Oh, excuse me, Representative
No,
Weber, go ahead if you have a response.
I don't have a response. Thank you.
Representative Gugemas.
Thank you, Madam Chair. Some of these places, these home communities, they actually hire out lawn care. And my concern is that would possibly, I mean, if you take care of your own property, I fully agree with this, because you would be in charge of taking care of your own signs and mowing around them, trimming around them, whatever, removing them. But my concern is those places that farm out the lawn maintenance, that would fall on them to take care of those signs and mow around them. So I wasn't sure how that would work.
Representative Weber.
Thank you, Madam Chairman. Representative Guggenmoss. It's been my experience that the signs are easily removed unless they're a bigger sign, which are attached more with a post to the ground and could be easily mowed around, or use a weed eater.
Further questions for Representative Weber or comments? Vice Chairman Ottman.
Thank you, Madam Chairman. Representative, what I was wondering about, and you had spoken a moment ago about the penalty portion of that, when it was talking about a penalty and then against the homeowners, usually that's an association. So I was wondering how that, it's not really an individual, or how do you see that being? Because usually an association is a member board.
Representative Weber.
Thank you, Madam Chairman and Representative Ottman. I know under the penalty phase, this is some language that I would ask LSO to help with, and I respect that Representative Yin offered another alternative idea for that. As a further amendment, Madam Chairman, may I continue?
Please.
On page 3, lines 9 through 13, it talks about signs being displayed. I had originally thought that, 90 days before the primary election and 30 days after. This is a long length of time, and the county clerks in most counties in Wyoming you can put signs up maybe as early as upon candidate filing, or even up to maybe 3 days before the primary. And then when it comes to taking the signs down, it's a variety of days and times. And I would like to work with LSO to come up with the language, because we have 23 counties, and there could literally be 23 different dates on that, to coincide with what the county clerks are currently doing with their election law.
Thank you, Representative Weber. So we don't have an attorney on staff here for our committee, but I would invite you to bring either the committee can work a conceptual amendment if the committee chooses, or you can do that yourself as the bill sponsor as well. So, further questions for Representative Weber? Representative Clauston.
Thank you, Madam Chair, and thank you, Representative, for bringing this. You know, one of the questions you're going to get that you kind of touched on, but maybe I just want you to elaborate on it a little bit, is loss of local control of these associations, setting their own rules versus individual rights. So if you could just kind of review that for everyone.
Representative Weber.
Thank you, Chairman Rodriguez Williams and Representative Clauston. So if I'm to hear you right, you're wanting to know about the homeowners association and the rights to put up a political sign or maybe even a patriotic symbol such as our American flag and what I think of that.
Representative Clauston, if you can clarify, it
you,
sounds
Madam
like
Chair.
Thank you.
leaning towards maybe state law versus contractual law?
Exactly. So, you know, this state law is going to override what the homeowner association may have set up. You know, so what you're going to hear is I moved into this association with these rules and now they're being changed on me. So you're taking away the rights of that association to set their own rules. And we're going to put in the state law above that. So it's one of the arguments you're going to hear. So just wondering how you're going to address that as those questions come up.
Representative Weber.
Thank you, Chairman. Thank you, Representative Clauston. You know, I think we have our God-given rights for our First Amendment rights as to have freedom of speech and freedom to show who we support. America would be some of that. And in the political arena, these homeowner associations and condominiums, we have hundreds of people that live in them in my county and throughout the state. And these elections are important. And I know many people, whether you're on this side of the aisle or the other side of the aisle or have different beliefs, people want to show their support and show what they value. And I think that's important.
Further questions for the bill sponsor? Okay, seeing none. Thank you, Representative Weber. Don't go far.
Thank you.
I know you have another committee. I'd like to open it up to public testimony. Is there anybody in the audience? Actually, are there any government agencies in the audience that would like to come forward to testify? House Bill 339. Okay, seeing none, we'll move on to public comment. Any members of the public that would like to testify on Bill 339? Is there anybody on Zoom, Mr. Caldwell? Okay. I will close, any registered lobbyists that would like to come forward on House Bill 339? Okay, the seats are empty. I will close public comment on House Bill 339 and turn the bill back to the committee. Committee, what is your pleasure? The bill has been moved by Representative Gugemas, second by Representative Yin. Discussion and amendments. Representative Gugemas.
Thank you, Madam Chair. I like the bill. I used to live in one of these communities, and it feels like your voice is taken away. So I like the thought of giving people back their right to put a sign in to voice their political opinion in an election year. So I like it. Thank you.
Representative Yin.
Madam Chairman, thank you. This is, for me, it's a First Amendment bill. We have Second Amendment bills all the time, so I like when we see First Amendment bills. I do have an amendment. So what I would like to do, because I'm worried that we're gonna make people criminals when things get a little touchy in a homeowners association, right? If it's like one day out and someone accidentally removes a sign, I don't wanna make them a criminal. So what I'd like to do is strike on page 4 and 5, starting on page 4, line 17, strike all of section 2. So that will go until page 5, line 5. And if I have a second, I'll elaborate on that a little more.
Second.
Okay, the amendment has been moved to delete section 2, which begins on page 4 and moves on to page 5. Mr. Caldwell, do you have that? Okay, so it's been moved by Representative Yen and seconded by Representative Clauston. Discussion on the amendment.
So Madam Chairman,
Representative Yin.
Thank you, Madam Chairman. So essentially what this would do is it would still make it illegal for an HOA to do this, but someone who is wronged would still have a cause of action to go to a court and say their rights have been violated. Please reinstate my rights. So, but it wouldn't make anyone a criminal. What I don't want to do is create new criminals with this bill. So that's all it does.
Further discussion on the amendment? Okay, seeing none, by a voice vote and a show of hands, please. All those in favor of Representative Yin's amendment, please state aye.
Aye.
All opposed, no? No. Okay, Representative Yin's amendment has passed. Further amendments or discussion on the bill? Representative Yin.
Madam Chairman, I do think that it's a good idea to align with what the county clerks are doing. So I'm happy to get with you, Representative Weber, on figuring out what that amendment should look like. But if you talk with them and they have something that's good, happy to support it when it comes to the floor.
Okay. Any further discussion? Okay, sensing the urge to vote. Mr. Caldwell, please call the roll on House Bill 339.
This is a roll call vote for House Bill 339 as amended. Representative Klauston,
Aye.
Representative Guggenmoss,
Aye.
Representative Heft, Representative McCann, Representative Ottman,
Aye.
Representative Stivar, Representative Wasserberger, Representative Yin,
Aye.
Chairman Rodriguez Williams. Madam Chairman, that is 8 aye and 1 excused.
Thank you, committee. House Bill 339 has passed committee. Representative Weber, you'll present that bill on the floor. We'll move on to the next bill, which is House Bill 250, Defining Life and the Rights of Natural Persons, sponsored by Mr. Speaker. Welcome, Mr. Speaker. Good morning.
Good morning, committee. It's good to be here with you.
Please present your bill.
Thank you, Madam Chairman. Committee, thank you for the opportunity to be able to present this. I think this is something that, as in the battle to try to protect life and that right that we have in our Constitution to that right to life. One of the key parts of this is, as I've dealt with other litigation and am currently in other, transitional between courts and trying to establish the right to life and the protection of the rights of the unborn, is always seemed to be fall back to personhood. And when does life begin? What is a person and what defines that? I do believe this piece of legislation that I bring before you today, House Bill 250, helps and works towards that definition and that end. If you would, please, I'll take you through the bill and then we'll discuss, and I'd be glad to answer any questions you may have. Defining life and the rights of natural persons, an act relating to statutes and rules of construction specifying definitions and rules of construction for the term person and what a person would be defined as, making conforming amendments. So if we go back, we can skip on over to page 2 of the bill. As used in this statutes, unless the legislature clearly specifies a different meaning or interpretation for the context clearly requires a different meaning. Currently, person includes an individual, partnership, corporation, joint stock company, or any other association or entity, public or private. And then we change and add, when applicable to an individual, the interpretation of construction specified in Wyoming Statute 81103 shall apply to this definition. And we go on in 81103, rules of construction statutes for purposes of interpretation and construction under the Wyoming Constitution and all statutes of this state, the following shall apply. And individual persons are living human beings entitled to protection for their health. This right is a fundamental right entitled to full protection under the Wyoming Constitution. When applicable to the individual person, in quotes, is someone who possesses at least one of the following. And many of the discussions that I've had is like, okay, well then what is a life? Let's say if that life of a child is developing in the womb and it doesn't have a brain, but it has a brain stem. Is that life? Can it exist? Is that life going to be able to be something that's protected? Could that cause, the conversation that's come to me is, could that cause a doctor to to be in liability if he was to perform that abortion or find that out, or if that child was to be delivered? What were the responsibilities of the hospital to provide, means of care or anything like that? What this is an effort to try to do is to say, these are the defining points, and they must have these things in order to be defined as a person. They must have heart function, respiratory system function, central nervous system function, brain function, skeletal development or function, joint or muscle appendage development. All these go down through organ function. No parent, guardian, or legal representative of any other person shall make healthcare decisions causing harm to the function specified in paragraph Romanet I of this subsection, except as necessary when medically documented as a necessity to save the life of the mother. Going on to the last page, to save life of a pregnant woman, and except for the discontinuation of medical treatment or care that keeps a person alive where a doctor has documented that there is no chance of a meaningful recovery, all exception determination under this paragraph shall be evaluated by the Wyoming Board of Medicine. Definitions, rules, and instructions specified in this subsection shall apply to the Wyoming Healthcare Decisions Act. Specifically, the child, and what we're defining here as we go on, specifically, the child has a right not to have his or her life terminated. And that's what I believe the basis or the foundation of this is, determining what a human being is and what is life and what are the rights that are inherent in that life. And that's been a lot of to me, ladies and gentlemen, the discussion has been, that's a glob of cells. That's until it breathes air on its own, I've actually been told it's not human. Literally in testimony, unless it can fill its lungs with air, it is not human. I would have to beg to differ. And if you go even to the point where you would say those cells, when those cells unite, what else would come of that union except a human being if left to come to full fruition? Honestly, if we're going to look at it as just something we don't know, a fish, could it become a lamb? Could it become a bird? No, it's going to become a human being, unique in every way, separate DNA entirely. A unique individual, in and of itself, only one like it in the world. In creation, human. And so that is what this is an attempt to do, is to provide rights to that unborn life in that body that are the same rights that each one of us, ladies and gentlemen, enjoy right now. We have the right to be protected if we're attacked. We have the right to be able to live free and to be able to pursue happiness. But how does that right, and where does that right begin? Do we determine a cutoff line and say, okay, well, when you draw a breath, then your rights begin? Or that when you're developing and you are a human being, you're just at a different stage of that development, but no less human? And so that's the question we have. And and there's a part of this, as I did a little studying on this, what is human? And if you look under Wyoming statute number 6-104, it clearly defines that if there's an accident and a woman that has a child is injured in an accident or killed, and that child is killed, and it doesn't distinguish gestation length. If it was done without premeditation, they consider that as a homicide of the child, the unborn child. So already in our statutes, we have language that determines that that is a human being that is going to be considered in the judgment. If it was if it was non-premeditated, 20 years. If it was premeditated and the person that took the life of that mother knew that she was pregnant, and it doesn't determine gestation length, it just says that she was pregnant. What is pregnancy then? Pregnancy is the joining and the conception of the child, that she's pregnant. 40 years, if you knew it. What I believe this piece of legislation is making an effort to do is to do a better job of defining and to try to put that in print. And to be able to say that that person is a person if they carry these things. And to be able to try to identify and define personhood so that we can actually in our laws say that they have those rights that all of us enjoy that are breathing. that are walking, that are talking, that are here. You know, there's some discussion out there that says, well, viability. To me, when I look at viability, I have grandkids. You know what? My week-old grandchild is he viable? Can he maintain his life on his own? He needs help. He needs support. He's not sustainable. Can a 2-year-old, are they viable? Okay, well then back down inside of that. Okay, no, that little tiny fetus, that baby, that whatever you want, zygote, whatever that you want to use to define a term of a development, are they viable? Well, if left alone and to develop, yes, they are. They will grow and they will develop into a human being, much like and very similar to and exactly like the body I stand before today. And interestingly, no two of you look alike. You're unique individuals created at that point. And I believe that all of us need that opportunity to have that definition of what humanity is, to have them and be able to enjoy those protections. So with that, ladies and gentlemen, I would try to answer any of your questions.
Thank you, Mr. Speaker. Questions from the committee? Representative Yin.
Mr. Speaker, I have a couple questions, as you may suspect. Thank you, Madam Chairman. Sorry, apologies. Mr. Speaker, so this, I mean, I see this bill as essentially an attack on the judiciary because we're telling the judiciary how to interpret the Constitution. It literally says that on page 2, line 14. So I'm curious on why, I mean, that's the extent of the bill. It's telling the courts how to interpret the Constitution, which, as precedent has said, is their power, not ours. So because it's an attack on the separation of powers, I'm curious on why you didn't refer this to the Judiciary Committee instead of this one.
Madam Chairman.
Mr. Speaker.
Thank you, Madam Chair, and Representative Yin. It's a good question, and I'm glad to answer that. Our judiciary asks for definitions. In my conversations through the process of dealing with other life legislation, I've asked the judiciary. They said, you know what we want? We would love to have definitions from our legislature as they propose bills, and then they present them to us to be able to give us the opportunity. They said, because that shows legislative intent. I know there's a lot of people out there that would say, we don't want to put definitions in our legislation, but they said, the gentleman I spoke to, who now is just retired as of our Supreme Court, he said, legislative intent, definitions, defining, helps us to be able to better understand what the legislature was trying to accomplish. They said definitions do not hurt. They do not remove the responsibility or the ability of the judiciary to make determinations. It simply helps them to be able to determine legislative intent. And so to answer that question, as far as why I didn't send it to judiciary, it also might have been the fact that judiciary is piled full of bills. And so as a good indication would be the previous bill you guys just discussed, which is whether or not a person can put a voting sign in someone else's yard, and you handled it quite well. So anyway.
Follow-up, Representative Yin.
Madam Chairman, thank you. Yeah, so, usually when we put definitions, we don't say for purposes of interpretation under the Wyoming Constitution. But my second question ultimately is why you explicitly exempted the Wyoming Healthcare Decisions Act at the end of page 4, which deals with end-of-life directives. So why would these apply only to the beginning of life, but not the end of life?
Well,
Mr. Speaker.
Oh, excuse me. Thank you, Madam Chairman. But through you to Representative Yin. I wanted to stay specifically to the beginning of life, defining of life, because I think that's one of the biggest issues we face right now is when does that begin? The fallback is, well, it's not human. It doesn't have rights. It doesn't deserve the same protections. I guess I would just end on that. I think that's just what we're trying to find is the struggle we're dealing with, and I think the thing that we're trying to really clear up for everybody is it human? Is it a life? Does it deserve the same protections in the beginning? I think we understand that when somebody of ripe old age or for whatever situation they're facing, they're human, they have rights, they have the ability to be able to be and enjoy the protections that our laws currently allow. The problem that we've really wrestled with is when does that protection begin? And that was the attempt of this bill.
Further questions for the bill sponsor? Representative Gugamas.
Thank you, Madam Chair. On this topic, I'm fascinated because science has shown what happens as soon as an egg is fertilized, and that there's a split-second ball of light that happens. It's just a split second, and then it disappears. And science cannot explain this phenomenon. They have no idea. My thought on that is that's exactly when the spirit of that child goes in. And then life is there. It does happen right at that split second. So thank you for bringing this bill.
Further questions for the bill sponsor? Yeah, Representative Clauston.
Thank you, Madam Chair, and thank you, Speaker, for bringing this. When we start looking at these functions, do you have any idea of when we're looking at timeframes here? I'm just looking up, the heart gets 4 chambers at 6 weeks. You can detect the heartbeat with the Doppler ultrasound at 10. So I'm just looking at heart function there. We could go through all these individually, but do you have time, weeks associated with each of these functions?
Mr. Speaker.
Thank you, Madam Chair. Representative Clauston, as far as giving you specific times, we can even discuss all the way down to 10 weeks or less as they be able to see motion of the heart. Be able to detect, no, you'd have to go through another form of being able to pull that sound. What we're talking about here is the ability to be able to provide strict, basically scientific backing that this is human, that this is functioning, that this is viable life that is deserving of protection. To be able to tell you how to determine that or what stage that develops at, I can't tell you. I won't try to bluff and make something up here for you because I just don't know. I would leave that to the medical doctors to be able to explain. This is basically laying out the fact that these are responsibilities that need to be addressed and need to be respected in the fact that this is human and that this is life and that this needs to be and is deserving of the protections that our laws allow. And so that's one thing I would be able to offer on that.
Further questions from the committee? Okay, seeing none, thank you, Mr. Speaker, for presenting your bill.
Thank you, committee.
We have a little bit of time left. Please raise your hand if you plan on testifying on House Bill 250. So 1, 2, 3, 6. Looks like we have 6 in the audience and 5 online. Or approximately 5 online, last that I heard. So if you are with a government agency and would like to testify on House Bill 250, please come forward. Okay, seeing none, members of the public, we've got 3 seats up here. If you'd come on up and fill these chairs, that would be great. Don't be shy. I'm going to limit testimony to 2 minutes, and if we can try to say something new or bring something new to the committee, that would be great. Please, ma'am, go ahead. State your name and we'll hear your testimony.
Thank you, Chairman Rodriguez-Williams. My name is Jeanette Ward. I am for this bill and I'm testifying on behalf of myself. I've heard the executive director of an agency whose initials are WMS testify before this very committee that during pregnancy there are 2 patients. I wholeheartedly agree. That second patient is a person worthy of protection. And this is the main bone of contention between the pro-life and the pro-death. Is the result of conception between 2 humans a human? Well, is the result of conception between 2 horses a horse? Abortion is not health care, it's death care. It results in the death of a human being. Pregnancy is not a disease. Does the baby have a right to choose? Everyone should have a right to control their own bodies. I agree. How about the baby? Does he or she get to decide if he or she wants to be killed? I urge you to support this bill.
Thank you, former Representative Ward. Sir, please state your name and your take on the bill, and we'll hear you for 2 minutes. And again, please come forward and fill these chairs if you plan on testifying.
Good morning, Chairwoman. Thank you, committee. My name is Dr. Marcus Coolidge. I'm a third-year family medicine resident. I really am still trying to figure out legislation a little bit. My question and concern with this bill is in page 4 or page 3, line 19, where it says no parent, guardian, or legal representative of any person shall make healthcare decisions causing harm to the function specified in paragraph 2 is, I guess, things like chemotherapy for children. How does that come? Like, that is something that's going to cause harm to someone that we've defined as a person, and I don't see how that would be excluded from this, or if even something like a vaccine where we're gonna, if you think of the skin or the integumentary system as an organ function, like the purpose of of that is to protect the body. If we're gonna put a needle in there, that's specifically gonna go against that. And I understand the intent of this bill, but it seems as though that section there basically bans us from doing any harm to an organ function that is clarified above. And then those are the two big ones, but any medication can potentially cause harm to these functions here. So it seems like that's going to be very, very limiting to be able to perform any sort of pediatrics. And I don't know how that would be fixed, but it just, like, that's my interpretation of it. If that needs to be clarified, I'd appreciate it. The other thing on here, which I think is addressed in on page 4, lines kind of 1 through 4, with like no chance of meaningful recovery. There are numerous medical conditions where someone can have a respiratory system, but no development of a brain. So I think the point of that line is to say, like, if there's going to be, like, if we can see on an ultrasound that the brain has not developed, like, then we are able to, that it doesn't apply. I just want to make sure that's clarified, or if there's clearly been no, like the heart, there's conditions where the heart does not develop, or there's a lot of, but one of those functions could still potentially be going, and so how that would be clarified. And I think that line's there, but I just would like some clarification. I'll stand for any questions. Thank you.
Mr. Coolidge, thank you for your testimony. Thanks for joining us this morning. Sir, please state your name, and we'll hear your testimony for 2 minutes.
Okay, good morning, Chairman and members of the committee. All exception determinations under this paragraph shall be evaluated.
Sir, if you could state your name,
Oh,
please.
Greg
Thank
Hunter, I'm sorry, from Laramie.
you. Thanks.
All exception determinations under this paragraph shall be evaluated by the Wyoming Board of Medicine. The very idea that the Constitution supports this notion is a clear indicator that Republicans are forcing their corrupted interpretation of the Bible into law. The submission of this bill proves that the religious of today do not understand why the founders put the First Amendment first. They put it first because the founders knew if the religious took root, corrupting the first, the only way to remove the threat to the republic was option 2. History has shown what damage can be done when we decide to take up a cause that denies citizens obvious rights. As I point out that it was Wyoming men that voted prohibition in. So I'm here to bear witness to a dystopian rhyme, as this law is grotesque and way worse than banning alcohol, don't you think? It's depressing to come to this committee to observe the casting of the first vote to end our republic by affirming that our Constitution can be used to classify women as a birthing vessel controlled by an unknown group. Really, what will be next? Selecting breeding pairs, deciding what the breeding vessels can wear? What will be next? I'll stand for any questions.
Thank you, Mr. Hunter, for joining us this morning and for your testimony. Sir, please state your name and who you're with, and we'll hear your testimony for 2 minutes.
Madam Chairman, members of the committee, my name is Mike Lehman with the Catholic Diocese of Cheyenne. As you know, Madam Chairman, we're nonpartisan. And what that means is at the end of every session, there's a chance that I might potentially offend just about everybody. If you testify about the dignity of migrants, some will think you're a leftist. If you testify on the dignity of the unborn, some will think you're far right. But I think we could all use a reminder that humanity does not serve politics. Politics serve humanity.
I'm not a political strategist. I don't know the best way to get there when it comes to defending the unborn, or if this bill does that, but I see the intent is to codify what we already know. What our speaker mentioned earlier about if you assault a pregnant woman and that pregnancy ends, you could be charged with homicide. When a mom has a long-awaited positive pregnancy test, she doesn't go celebrate by getting drunk. We know these things. We all know this, whether we're talking about the preborn or migrants. Some will try to use either one as political pawns. But for many, we're just trying to hold these two pieces of our humanity together and be reminded that politics should serve humanity. Madam Chairman, I would stand for any questions.
Thank you, Mr. Lehman, for your testimony and for joining us this morning. We have a few more minutes. Please come forward if you'd like to testify on the bill, House Bill 250. Good morning. Please state your name and who you're with, and we'll hear your testimony.
Thank you, Chairwoman. My name is Travis McNevin here on behalf of ACS-CAN. It's the American Cancer Society's Cancer Action Network. And to be very, very clear, the reason I appear before your committee at this time today is to simply raise a potential unintended consequence. And I will limit my testimony only to commenting on the definition. As it states, the no act or treatment or procedure that causes harm, and then that definition continues to unfold. And the concern here is the definition means any essential cancer treatments, including chemotherapy, prescription drugs, or surgeries, could fall outside the state's definition of healthcare for all of its residents, regardless of age, men, women, children, et cetera, that may need these services as they fight her battle with cancers of various types. And so it is with this concern, this unintended consequence of the bill, and that issue that we asked the committee to consider and thinking through that potential issue, just as it falls within there. So again, the testimony is just around that, not the greater portion of the bill and the discussions, one way or another, just that narrow piece, and certainly happy to take any questions.
Thank you for your testimony and for joining us this morning. We have a few more minutes if anybody else would like to come forward in the audience. Good morning, ma'am.
Some of the issues that we were concerned about have already been mentioned, including these kind of unintended consequences. And I think there are a number of unintended consequences of this bill. The court has recently said the court cannot reconcile how a small group of prenatal cells, such as a zygote that has only the potential of life, can trump the fundamental right of a living, breathing, pregnant woman to make her own medical decisions. And part of this testimony was that we have the right to live free and we have the right to make our own decisions. This puts the rights of the fetus above the right of a pregnant woman to make her own decisions, along with her medical caretaker and her family. This could affect contraceptive issues if enacted as it stands. Child endangerment laws could apply as a result of the fetus being considered a person. The state could actually regulate a woman's behavior under this law, including drinking, eating, diet, nutrition. Since the only abortion is to save the life of a mother, any kind of other things, including damage to her reproductive organs, damage to other organs in her body, could not be considered. It could also affect someone who suffers a miscarriage, which if she was seeking management care, she might be challenged as attempting an abortion. These would also be very difficult provisions to enforce. It would be necessary to have all of these 7 conditions defined as a person. And I think the unforeseen consequences of a bill like this could go on and on. The other thing is in terms of the constitutional interpretation, yes, the legislature has the absolute authority to give definitions. It does not have the right to direct interpretations to a court of any nature. And I will stand for questions.
Thank you for your testimony.
Thank you.
Oh, wait, Ms. Burt,
Oh, I'm sorry.
we do have a
Absolutely.
question from Representative Yin.
Ms. Burt, thank you.
Please, Representative Yin.
Madam Chairman. Madam Chairman, Ms. Burt, so your testimony is basically saying this would make the already existing abortion ban that we have on the books even stricter. So any exceptions or carve-outs that we had in this abortion ban, this would trump all of that. Is that
Madam
correct?
Chairman.
Ms. Burt.
Madam Chairman, Representative Yin, this is basically a ban on all abortions is what it is. That's strictly what this does. And the unfortunate thing about part of this is none of these definitions come from any medical personnel, and none of these ideas come from any medical personnel. And I think it's been testified that part of this is a religious belief, which I absolutely and totally respect, but not as it applies to women's decisions to make their own decisions under their own religious ideas and religion. So
Thank you.
anything else? Thank
For
you.
your testimony. Okay, we have one more. Good morning. Please state your name and we'll hear your testimony for 2 minutes.
Thank you, Madam Chairman and committee. Nathan Winters, President of the Wyoming Family Alliance. I didn't intend to actually speak on this, but I do want to correct the record for some. I rise to mention that the defense of the right to life is not, as has been asserted by some, a constraint on the First Amendment. Indeed, it's actually an appeal to the self-evident truths the First Amendment was designed to protect, and that is the right to life. I believe that future history will judge our society on how we defend the weakest and most vulnerable in our society. That is actually the role of government, to step in and intervene on behalf of those who cannot intervene for themselves. And this is something that, as a passionate Christian, I am appreciative that people like to come up and say, hey, this is just based on your religious belief. But it isn't. It's based on the fundamental nature of what it means to be human and to defend the basic right of humanity, the right to exist. This is the right to life, and it's understood by all of society, regardless of where you go. And so, though I do understand how some people try to just paint this as a religious issue, it isn't. Every decision that anyone makes is based in their worldview. But I will say the worldview that life is of value should be important to everyone. Thank you, Madam Chairman.
Thank you, sir, for your testimony and for joining us this morning. All right, we will continue public comment through Zoom when we reconvene after adjournment this evening. So those that are online, please, if you can, join us after we adjourn this evening. And committee, this meeting has been adjourned.